Hello, my name is Brooke Beery and I am an attorney with the Packard Law Firm. Today I'm going to go over some issues that are specific to our clients whose medical impairments arise primarily or exclusively from mental health conditions. Unlike cases that involve a lot of physical issues where the government's looking for objective imaging and surgical procedures and physical therapy, in mental health cases, the medical records are often more subjective in nature. There isn't going to be an X-ray or an MRI that a judge can evaluate. The cases have to be decided based on things like therapy notes, medication management, and inpatient hospitalizations. I'm going to talk about each of those three things today, and then I'm also going to mention listings toward the end. First of all, therapy notes. The most important thing that you as a client can do for your case is to be honest and open with your providers. This is your counselors, your therapists, and your doctors. Since mental health conditions are not visible, it's important to clearly communicate with your providers about your symptoms, how often you experience them, and how severe they are. Social Security considers an impairment severe when it's impacting your ability to perform daily tasks. So if you're struggling with daily task issues, discuss these things with your provider. If you're having difficulties with motivation or crowds in grocery stores or have memory or concentration issues, discuss these. If you don't tell your doctors, they won't put it in their notes, and the judge cannot write a favorable decision based on medical records without that pertinent information in it. Secondly, medication management. This is another big issue for mental health clients. A judge will want to know three main things about your medications. Number one, compliance. Two, side effects from those medications. And three, what are those breakthrough symptoms you're still experiencing? So number one, compliance. Are you taking your medications as prescribed? If you've had issues with your medications for any reason, financially you couldn't afford to take them, they were causing very severe side effects, you were trying different ones out, whatever the reason may be will appear in your medical records, and the judge is going to want some clarification if there's any kind of compliance issue about why you were not taking your medication as prescribed. Second is side effects. The judge is going to want to know what kind of side effects you're experiencing and how debilitating these are in your daily life. And then third, those breakthrough symptoms. This is the things that you're talking to about in your therapy notes. These are the symptoms that you're still experiencing despite the fact that you're taking the steps to take your medication as prescribed and you're doing the therapy programs that you're in. The judge is going to want to know if you feel that your medication is making those symptoms better, making them worse, or if you're about the same. If you have been hospitalized or treated at an inpatient facility where you stayed overnight, the judge is going to want to know about how long you stayed at that facility and what improvement you experienced after your discharge, if any. They may also ask you about follow-up treatments after you were discharged. If you take nothing else away from this video, remember to be open and honest and detailed with your providers. Talk about your continued issues, any medication side effects that you have, and do your best to be consistent and make your appointments and take your medications as prescribed to the best of your ability. Don't stress over things like listings with a bunch of detailed line-by-line requirements. Your attorney will discuss your case with you before your hearing, and we will tailor your legal arguments to the specifics of your case. Thank you for taking the time to watch this video. I'm Brooke Beery, an attorney with Packard Law Firm, and I look forward to representing you in your mental health disability claim.